good afternoon. Thanks for joining us. My name is Diane Millette. I'm the registrar of the college. And today we're hosting our webinar on public protection, which is really all about complaints, discipline, and support programs. The staff team today are in Vancouver, and I'd like to acknowledge that we are located on the ancestral and unceded territories of the Coast Salish peoples, specifically the Musqueam, Squamish, and Tsleil-Waututh peoples. I'd like to introduce our speaker today, Lainey Shore. She's going to be hosting the webinar. Lainey is the Regulatory Transformation Advisor for the Inquiry, Discipline, and Monitoring area within regulatory programs. Lainey is a lawyer, and she comes to us from one of the legacy colleges where she was a deputy registrar. But Lainey has a long history in regulation. She has worked for the Law Society, the Architectural Institute, the Real Estate Commission. So she is very well versed in regulation and has a very strong background in not only complaints, discipline, and monitoring, but also quality assurance and standards. So with that, Lainey, I will turn it over to you.
Hi, everyone. Thanks for joining us. And thank you, Diane, for that introduction. I'm actually going to tweak one of those things. And with respect to the Real Estate Commission, I actually acted as defense representing their registrants or in front of them. So I have a bit of experience on both sides of the complaint spectrum. And today, as Diane mentioned, we're going to talk about the public protection. So I'm having some issues with slides. Naomi, do you mind advancing? You can go right to the agenda slide. Thank you. So just a quick overview of what we're going to cover today. I'm just going to do some quick reminders about the HPOA. We're going to cover the complaint process, discipline, and support programs, and then hopefully have time for some questions. So just as a reminder, if you don't know already, that the Health Professions and Occupations Act is coming into force on April the 1st. There have been college bylaws that were drafted under the HPOA. They were posted for consultation, and they included bylaws in respect of public protection. Comments that were received were considered, revised as appropriate, and then there's going to be a final set that are going to be posted online, and of course they'll be presented to the board for approval. And I also just want to remind everyone that unique to the HPOA is that it sets out some guiding principles that govern how the college will be operating in respect of its regulatory programs. And those guiding principles require us to support and promote awareness of reconciliation with Indigenous peoples. This is not new, that we must protect the public from harm, but there is now also a requirement that we protect from discrimination and take anti-discrimination measures. Another guiding principle is that we promote a holistic healthcare system that encourages collaboration between all of the regulatory health colleges and that we all act in a transparent manner. And of course, all of this has a bearing on complaint investigations and discipline. So just before I launch into what the public protection process under the HPOA entails, I just wanted to put some things in perspective. So in plain language, public protection is the complaint investigation process. And I'm sure for many of you who are attending, hearing complaint investigation process makes it really stressful. But just to keep it in perspective, while being the subject of a complaint is stressful, and we acknowledge that, our current statistics would show that less than 1% of all of our licensees have an active complaint. So just bear that in mind as you hear the presentation, that it's a very minuscule number of the overall licensee base that actually even comes into contact with this process. And I also just want to flag, we could probably do a whole presentation on this, but there are aspects of your practices that you can control that mitigate the experience and the outcome of a complaint investigation should you find yourself being the subject of one. And I'm just going to flag the three biggest areas that come up, which is you need to be documenting your charts and files and do that thoroughly. Contemporaneous notes are key in a complaint investigation. Another big area is to ensure that you're acknowledging and documenting adverse events. It's very easy when something awkward or embarrassing has happened, but when you don't document and acknowledge it with your clients, it leaves it open to misinterpretation, and it's a big source of complaints when your clients don't understand why something has happened that wasn't addressed in the room. And the last thing I want to just highlight is to be mindful of communication style, because that is probably the root of every complaint we get. Even if there's more serious components to it, at the end of the day, how we communicate with our coworkers and our clients and everyone that we encounter within the system is really key to really avoiding complaints at the end of the day. So just keep that in mind, that it's a small percentage of licensees that have complaints. And again, there's numerous aspects that are within your control to manage should you become the subject of one. And with that, I'm going to just cover what remains the same in complaints, because currently, of course, we do have a complaint process. So at the end of the day, what stays the same is that licensees must meet clinical and ethical expectations for their practices. Those expected practice standards are available online for everyone to familiarize themselves with. The process will require complaints to be in writing and include sufficient information, which is the way it is now. And we do assist on a neutral basis, but of course, if there's someone from the public who can't put it in writing, we do have sources to assist them with that. And again, I just want to highlight that we do take a right touch approach to regulation at this college, which means that we really approach our investigations with an understanding that receiving a complaint is stressful and impactful on the licensee. We can't control that there's a process that you have to go through, and it might seem very burdensome, but at the end of the day, all of our investigators are very mindful of the stress that being the subject of a complaint creates. Next slide, Naomi. Oh, yeah, thank you. Okay, so now moving into some of the new terminology that the HPOA creates. And some of this might be familiar. Well, the first one potentially is that registrants are now going to be called licensees. And in the complaints process, there's also a new additional term called respondent, which is kind of self-explanatory in that you are the party responding to the complaint allegation. But the Act is kind of uses licensee and respondent kind of interchangeably. So you will see both of those words in response to complaint processes. Another key change is that the inquiry committee now becomes the investigation committee. And another thing that some of you may have heard of, but not all, and we'll talk about them a bit more in the presentation, is that Section 35s are now called summary protection orders. And both of those things basically grant the power for the committee, currently the inquiry, soon to be the investigation committee. It allows them to take an immediate temporary action against a registrant or licensee during an investigation or awaiting a discipline hearing if the committee considers that action is necessary to protect the public kind of before the end of that process. So we'll talk a bit more about that under summary protection orders, but just to be clear, that's new terminology, but not a new process or a new power. The other, probably one of the big changes, is that under the current legislation, in terms of what gets investigated, was kind of vaguely referred to as a serious matter, and there was no definition of what constituted a serious matter. Now, under the HPOA, it refers to misconduct and provides us with an explicit list of what will constitute misconduct. So now those things include a failure to comply with the Act bylaws or an order under the Act, sexual abuse and sexual misconduct, an act of discrimination, neglect of a patient, an act of physical, emotional, or financial abuse, something that results in limits or conditions or suspension or revocation of a license, and conduct unbecoming. And again, maybe not everyone knows what conduct unbecoming is, but it's kind of a catch-all phrase for behavior that's really outside of your professional practice. And it's kind of an action that would kind of have the member of the public go that someone with the responsibilities of being a regulated professional ought not to have done that. So for example, the most common one that comes up is when you've been convicted of a relevant offense, and that can be assault, could be uttering threats, things that often come up in people's personal lives that do generate interest from the college and ultimately can land you in the complaints process. Next slide. So here is a very long list of new concepts that the HPOA has inserted into the complaint investigation process. I'm going to do a high level because there are so many bullets, as you can see there. I'm not going to read the list right now. We're going to work through all of them, but there are numerous new concepts that the HPOA is implementing for the complaints process that the college is now currently working on all of those areas to create processes and policies around them. So the first one is administrative matters, and it's important to note that that's distinct from a complaint investigation matter. So an administrative matter, again, is defined in the Act, and it actually includes specifically an alleged breach or contravention of an undertaking that could be given under the Act, the duty to cooperate, and that can be things like if you are subject to a complaint and we ask for your response and you fail to respond, delivery of records, a CRC, All of these things are set out in bylaws, but so the duty to give notice, continuing duties, duty to provide information, duty to practice in an accredited facility, duty to provide a certificate of professional conduct as needed, and to comply with the discipline order. And what makes this unique is that under the old regime, all of these, should they occur, would require a full complaint investigation process. So that could be something like someone who didn't have professional liability insurance, let's say, it came to the attention of the college that there was a gap, that would then be referred to a complaint investigation process. And now things like that, failure to pay fees, for example, things like those are falling under this defined category of administrative matters. Next slide. So this is, again, it's unique and new to the HPOA, and it's going to allow the registrar, instead of going to investigations committee, to take action by making an order on what is an administrative matter. And again, those are those categories defined in the Act, so we're not choosing them. But in the event of those matters, the registrar is entitled to act by making an order to dismiss. So if one of those things come up, and let's say it's already been quickly remediated, the registrar has the ability to dismiss the administrative matter. We can accept an undertaking from a respondent. So that could be something like not to repeat the conduct in the future. It can be for a reprimand. It can be to take any specified actions to remedy the breach. So that can be an order to pay your fees if you hadn't paid them already, and that was the type of breach, or to comply with the undertaking that you already had given and were not meeting. It can be a direction to take specified education or training or remediation. And then there's two additional categories, which, if authorized in bylaws, which ours are, allows for the registrar to make an order to put a limit or condition on someone's practice, or to suspend for a specified period of time. And again, this is also something that's new, and something that we're being mindful of is that under the HPA, generally we were able to say that we don't direct our licensees to pay a refund. However, the HPOA does authorize that we can make an order requiring a licensee to pay a monetary fine or to give a refund for service. And of course, I do want to note that if an administrative matter results in an order, the registrar will provide detailed reasons in writing to the licensee, and the respondent does have an opportunity to apply for a reconsideration, and that would go to the investigation committee. So just a little bit of elaborating on some of the summary actions that now are allowed under the Act. So this is something called the summary dismissal order. And this is now an opportunity where something can kind of, as it sounds, be similarly dismissed. And that's in the specific context of where, let's say, a complainant fails to provide the information or records to substantiate the complaint. If a complaint is found to be trivial, frivolous, vexatious, an abuse of process, or bad faith. And then the slightly more complicated is if the allegations in the complaint, if they were to be admitted or proven, does not indicate the respondent is not fit to practice or has committed an act of misconduct. That one will be a little tricky and is probably unlikely to result in a summary dismissal order, because most of the allegations, if admitted, would constitute one of those things. So it's probably not going to lend itself to a summary dismissal order, but the option is there. And again, as a summary dismissal order, particularly if it's dismissed outright, the Act does provide that the registrar can include a warning, advice, or information within that summary dismissal order. And of course, that should that happen, it's intended to be helpful to improve for the future and avoid similar circumstances from happening in the future. So this is now another summary action, and it's called the Summary Protection Order. It's the matter that I referred to earlier. And again, colloquially at the colleges, we're referring to it as the new Section 35. And I just want to be very clear, this is not a new power or a new means or a mechanism for the college to have. It's essentially, though, a means to take quick action to protect the public by temporarily restricting or suspending a licensee's practice during an investigation or discipline hearing before any final decision is made. And so in order to have that, it's the decision that is made by the investigations committee. And in order for them to issue the summary protection order, they must have reasonable grounds to believe that the professional poses a risk of harm to anyone or is giving false or misleading information to the public that can cause harm. And I would suggest that that second bullet there is probably a result of COVID, that the ministry has included that specific reasoning for when a summary protection order may be ordered. Again, the respondent is entitled to give reasons, will receive reasons. They're also entitled to make a submission as to why a summary protection order might not be appropriate. And again, if one is ordered, there is a right of appeal by the respondent back to the investigation committee. Nothing about that process is new, though. I just want to clarify. There's just some new wording, but in terms of those things do happen occasionally, currently, and that process is very much the same. So applications for reconsideration, however, is a new concept. There was not a formalized process for reconsideration under the Health Professions Act, but now respondents can apply for a reconsideration of a registrar decision or an order. They can apply for a reconsideration or review of a registrar's disciplinary order that's made by the investigation committee. And just some parameters around it is that it must be made within 30 days of the decision or order being delivered to the respondent. And it must be rooted in one of four of the following grounds. So you can make an application for reconsideration if you feel that the decision or order was made contrary to the act, regulations, or the bylaws. In the event that you feel, as the licensee who's received the order, that there was procedural unfairness, perhaps you weren't given an opportunity, there is some narrow provisions for when notice is not required. So that could be a scenario where you might argue that for procedural unfairness reasons, the matter should be reconsidered. You can also apply if new information becomes available that's material and relevant that wasn't available at the time when the decision was made. And the fourth grounds for applying for a reconsideration is that new information has come up that establishes a change in circumstances since the decision that would warrant a reconsideration of the original order. So the investigation committee continues to exist. It's just, well, the inquiry committee has now transformed into the investigation committee. And this committee will continue to deal with what are really the high-risk complaints that require in-depth investigation. And this list is not exhaustive, but it will include allegations of discrimination, sexual misconduct, sexual abuse, and competency issues. The investigation committee is composed of licensees and public members. And I really want to emphasize, because I'm aware that this is a common concern, particularly with the Amalgamated College, the investigation committee that meets in panels, they meet by profession. So currently we meet in panels of 3. There are 2 representatives from the profession and then a public member who sit at the table to evaluate the complaints that come in. And to be very clear, it is done profession specific. So you have occupational therapists being the representative of the licensee at the investigation committee panel for a matter that involves an occupational therapist. So really clear, it is done by profession. And I also want to emphasize that where needed, the investigation committee has full authority to direct the college to obtain expert evidence. So if an area comes to the table where perhaps none of the licensees who are sitting in evaluation of the complaint, there could be an aspect of practice that they don't have. And so they are able to seek an expert opinion, and then they have that to assist them in making an evaluation of the complaint. So when a matter does get to the investigation committee, they're required to review all of the information and records that are obtained during an investigation. And then their job is to assess whether there are reasonable grounds to believe that a respondent lacks competence or has committed an act of misconduct. And again, specifically that what is misconduct was covered earlier in the presentation of being that list of items. When they make their decision, they give notice to the registrar to provide a written assessment and the reasons for the assessment that they made. And then again, this is a bit of a drawn out process that's new to the HPOA in terms of if you've had a complaint before, you might have seen that these actions were taken by the investigation committee, but now it goes back to directing the registrar to give reasons for the assessment, and the registrar then makes an order as directed by the committee. And again, another keynote is that there is now a requirement that dispositions regarding allegations of sexual abuse or sexual misconduct or discrimination will be approved in advance by the Director of Discipline. And that's a topic we'll cover in a few slides. It's a new role as part of the Discipline Tribunal, which exists as a standalone separate entity from the college. And again, that's a major change that the HPOA brings in our process. Another key new area that we're learning to deal with is that you might have heard in the past, or you might have asked, can someone make an anonymous complaint? And there's no doubt that occasionally we receive anonymous complaints. People like to make up a random email address and send in angry messages about someone that they may have interacted with. And for the most part, until now, we've been able to say, we don't accept anonymous complaints. And if you'd like to complain, here's the process. We still don't accept anonymous complaints, but there is a new tool created by the HPOA, which is called an identity protection order. So again, to be clear, you still can't really make an anonymous complaint because the college needs to know who you are. But should you bring forward a complaint or a duty to report, there is now a provision that allows you to apply, or the complainant or reporter to apply, for what's called an identity protection order, which will either partially or fully protect their identity in the complaint process. And again, this is probably common in areas where an allegation might be around sexual abuse, and that being involved in that might be triggering or embarrassing, so you don't want to use your identity. It can also come up if you're in a small community and you're making a duty to report against a fellow licensee, so you want to protect your identity. Unfortunately, while this is a tool that is out there to apply for, the reality is that in granting it, there may be a limit to investigating and resolving the complaint. And that is because of a ground called procedural fairness, which entitles the licensee to know the allegations against them in a manner that's sufficient enough to provide a thorough response. And so, unfortunately, there is a tension here between people who may want to protect their identity and the procedural and administrative law principles that do guide our complaint process to ensure that licensees are provided procedural fairness to be able to respond. And another reality that we will have to share with those who seek it is that often the facts of the complaint they're making may very well ensure that the registrant or licensee knows who they are. So the idea of really being anonymous is kind of potentially not genuine. But at the end of the day, the government has ensured that now people from the public may apply for these things. And there may be reasons where it is appropriate. I don't want to be entirely dismissive of them, but the reality is that they may be granted infrequently due to the impact on administrative fairness. Another expanded area is called competency assessments. And again, the HPOA has taken the task of really spelling out that now, within the course of an investigation, the investigator may order a respondent to undergo what's called a competency assessment. And essentially what that entails is a clinical evaluation of the respondent's performance of their profession. It could also entail another evaluation that's authorized under bylaws, but for the most part, it's going to be an assessment of whether or not that respondent is performing their profession competently. Key to note, the assessment will be conducted by a qualified assessor with relevant professional experience. It is important to note that if you're in the process and are ordered to undergo a competency assessment, a failure to comply may result in one of those administrative matters we spoke about earlier. And once the assessment is completed, that report will go back to the investigation committee for their review and forms part of the overall assessment of the underlying complaint as well. Another area, again, not entirely new, capacity evaluations. There were definitely files and situations that arise under the HPA where a licensee's capacity could be called into question. But the HPOA provides a very specific and rule-based formula now for the college to obtain a capacity evaluation. So if the investigation committee has reason to believe that a respondent might lack capacity, it has the power now to actually order a capacity evaluation. And just at a very high level process, the capacity evaluation begins with a capacity assessment that again is conducted by a licensee who's appointed by the registrar. That person becomes the assessor. The assessor will deliver the report after the assessment with recommendations to a new role in the college, which is called the capacity officer. And this is an area where you can see that it's slightly unique because in the past, if there was a capacity evaluation done, often it just went right to the investigation committees. And so in some ways, this is a positive twist because the capacity officer is going to be better positioned to review that report and assist the investigation committee in evaluating capacity and making a more informed decision. So that capacity officer is going to review the report and will assess whether the respondent lacks capacity based on that report. And then they have the ability to, basically they have to make another report to the respondent with the conclusion. And if there is a finding that there's been a lack of capacity, the capacity officer has the ability to issue a variety of continuing practice orders that can include requiring the licensee to go for education, training, or remedial activities, It may involve directing a course of therapy or clinical treatment. Examples of that are, should someone with an addiction challenge be presented, we can direct that prior to returning to practice, for example, that licensee needs to get treatment. It can require ongoing or further evaluation of treatments. Perhaps we have someone who has a capacity issue but is currently already dealing with it. So there can be an order that they require to do the things they're doing to treat their capacity challenges. Again, they can impose limits, conditions, or suspend a license if appropriate. And in the most extreme case, they could make a revocation order if any of those other lesser than types of orders does not address the harm, or again, if the respondent doesn't comply. And again, once again, this is an area where respondents will be able to apply for reconsideration should they be subject to having a capacity evaluation ordered. So discipline now is a new process. Up until the HPOA, discipline was embedded within the college's own process. And some of you might recall that there used to be an inquiry committee and a discipline committee. That is no longer. The college will no longer have a discipline committee or hold discipline hearings. All of this has been carved out to an independent body called the Discipline Tribunal. There is a director of discipline whose name is Benson Cowan. He's been appointed by the government and specifically the Minister of Health, and he oversees the Discipline Tribunal. It is the director of discipline who will now conduct any discipline hearings. The college retains the role to advance the college's case, which I have here as prosecute. Essentially, it's the college applying to present its case as to why there are concerns with the licensee's practice, and respondents will continue to be allowed to have legal representation in this process. So process so much is not new, but who oversees it and administers it is very new, and it creates a separation from the college to this new independent discipline tribunal. And as part of that new process, citations are now issued by the director of discipline and not the registrar. So in the past, under the HPA, if the matter was such that the inquiry committee felt that it needed to go to a citation, it was through the registrar process that happened. It's now decisions on citations are issued by the director of discipline. So the college would essentially be making a request for citation to the director of discipline, and that individual has the authority to approve or decline to approve the charge. And of note, again, prior to any discipline hearing actually going through, there will be a period to work on reaching a consent agreement after the citation is authorized. Some of you may be familiar with the Health Professions Review Board, and it does continue to have a role under the HPOA. The Health Professions Review Board, often shortened to the HPRB, that is an avenue for appeal for complainants. And it comes up most often following disposition of the complaint. If a complainant is unhappy with the decision they receive, they are entitled to apply to the HPRB for review of that decision. The HPRB is limited in terms of what it is allowed to consider when it does review a decision. And those areas of reconsideration are adequacy of the investigation. So they'll look at whether or not the college's investigation was thorough, was it adequate for the circumstances. It's not a perfection standard, but it has to be thorough enough that the allegations were thoroughly investigated. Was the outcome of the investigation reasonable? So was their decision reasonable? And this is a new area that the HPRB will have the power to look at procedural fairness. It's an untested new area, so unfortunately I don't have much to comment on that right now, but it is something that is new under the HPOA in terms of a ground that the HPRB will be looking at when it reviews or if it reviews a decision. And again, this is an area where if you look at the overall number of complaints and decisions that are issued by our college, we're quite fortunate that as of now, we don't have a high volume of going to the HPRB, but occasionally we do. Complainants are the ones who get to make this application, and their review or request for review must be made within 30 days of receiving the decision. And I will just note that licensees are involved independently from the college, but should there be a request for review of a disposition decision, the HPRB will communicate directly with you as the licensee. And you also, again, are entitled to give submissions to the HPRB as part of this process, but that is also independent from the college. Publication is an area I know that brings a lot of distress because obviously it does have bearing on individuals, reputation, and there's could be financial implications. But there is a requirement for publication both under the HPA and it continues under the HPOA, whereby summary protection orders, all disciplinary orders, and if applicable, and there's a request for citation, all of those must be published on the college website. And I just want to emphasize here again, this is not new. All of these matters were currently being published under the HPA, and so that is a continuing requirement. However, as we've covered, there are many more types of disciplinary orders that can be issued under the HPOA, and there are varying degrees of severity. So as a result of that, there's currently a working group that's composed of the Director of Discipline and then counsel from all of the health colleges. And we're working to ensure that publication of information maintains a balance between transparency and confidentiality. So we're looking to try and strike that balance, being mindful of the implication and ramifications that a public notice has on a licensee. So that kind of ends the portion of the presentation on all of the new sections under the complaints process. Support programs is another new program. It kind of fits into the complaint process, but it's also kind of standalone. Set out in Division 5 of the HPOA if you'd like to read about it. And ultimately, again, this is not a program that the college has chosen. It is required under the HPOA that all of the health colleges establish and fund a new program for certain complainants, which we'll talk about in a second. And this program is called support programs. There are 3 components, 1, information services, 2, support services, and 3, support workers. And we'll go through what each of those mean. The program, again, also creates a number of new statutory roles, which basically means the Act requires colleges to have people in these positions. So there's an administrator role, a support officer role, and then the support worker role. So in terms of eligibility in an application process, the criteria for being able to apply to the support program is that there must be an allegation of sexual abuse, sexual misconduct, or discrimination. Applicants will be required to submit information as defined in the program parameters, which are set out in our bylaws. And upon receipt of an application, this is where the multiple roles come in. The administrator will notify the applicant about the process, and the support officer has the role of assessing eligibility. So they will ensure that the applicant is meeting the basic criteria, that they fit into one of these categories. And yeah, I'll just leave it at that for now. In terms of what each of the different components entails, information services is the broad kind of what it sounds like. Its purpose is to provide information about the complaint process and help people understand their rights therein. So it's very broad. It's the information that's going to be on our website. It's information that people, really anyone, can receive if they call the college to ask about what is our regulatory complaint process, what are their rights and obligations in making a complaint, what does an investigation entail, what are possible outcomes, whether or not there's alternative processes. And so that really encapsulates what information services is, providing information. More unique is the second component here, and that is the provision of support services. And the purpose of this component of the program is for the regulator to provide funded counseling and culturally mindful therapeutic services. So if someone has alleging sexual abuse, misconduct, or discrimination and makes an application for a support program, and meets the eligibility criteria, they will be entitled to funded professional counseling or Indigenous support services as applicable to the individual. It's intended to provide trauma recovery support and be a therapeutic intervention to assist the individual who has been the subject of these alleged actions. And the third component is called the support worker. And so this is basically a trained advocate who is available to assist applicants or the recipient of the support worker program once the complaint has been filed. And it's a very unique role. There's a lot of requirements that are spelled out in the Act in terms of the very specified educational background that support workers must have. And their role is basically to provide, again, rights and processing of education during the investigation for the complainant. And if the matter continues into a disciplinary proceeding, they can continue into assisting the complainant in that process as well. Their role is really direct client advocacy, and they provide assistance in helping the recipients of understanding the process, navigating the process. If a complainant is being interviewed, the support worker is entitled to come to that interview and offer support and or advice. So it's a bit of a unique role. And I believe the next slide also cover, oh no, so this is, I was just going to say the support worker also has a unique ability to make comments on the complaint process outside of the file that they're specifically working on. And so the college is expected to be mindful of commentary from the support worker should there be issues identified by a support worker about our process. So again, so these are the support workers. Oh yeah, so now moving on to the other roles. The administrator is the primary program manager. So they have very specific responsibilities that are spelled out in the Act. They are the ones who administer the program on behalf of the college. They are technically responsible for publishing the program parameters and any orders that are made. They maintain the documentation, including processing application, managing any transfers between the program components. And by that, we would mean if someone wants both, let's say, support services and support workers, the administrator coordinates those different services that we're offering. They communicate with the recipient of the services. They are responsible for maintaining the support worker list. And perhaps key here is that they also manage the funding and any recovery of funding processes that the college puts in place. And the support officer, again, is a mandated role. It's an eligibility decision maker. So once the application comes in, it's the support officer who will assess and decide eligibility for what types of support an applicant might receive. They have to make decisions on the support provisions. They must provide written reasons for any of their decisions. And they're also the ones that should new information arise as the individual is accessing our support program, they can review the case and make changes as needed on new information that arises. Oh, and again, this is what I was referring to when I talk about the uniqueness of the support worker. So they provide direct assistance to complainants. And again, who these people are is spelled out in the Act. And workers must represent a diverse group of people. They must have expertise in helping those who have experienced sexual misconduct, abuse, or discrimination. They must have expertise in mitigating trauma and adversarial processes. And other relevant is quoted because that's how the Act puts it out. So any other relevant experience. And again, this is where I was referencing that the support worker can give information about any matter if, in the opinion of the support worker, it is appropriate for them to comment on the process to the college. And again, they are entitled to attend proceedings and investigations with the recipient of their services. Yeah, they can make recommendations on the entire college's complaint investigation or disciplinary process. And if, let's say, they do identify an area they think the college could do better, and one of their recommendations is not followed, in their opinion, adequately, they may make an oversight complaint to the superintendent's office about the college. That's now, again, this is not necessarily about licensees, but it provides some insight into the responsibility that support workers on the college has in order to ensure that our process is accessible and safe. And I want to just flag that there is a special requirement, again, that Indigenous representation is mandatory in the support worker pool, and it will include individuals who are nominated by Indigenous governing bodies. And just to highlight, so the guiding principles of this program is that it's the regulator's responsibility pursuant to the Act. The Act requires that the regulator is responsible for funding all of the amounts that are paid in respect of the program. So, I mean, concretely, that includes covering counseling services and payment for services of a support worker. I want to point out that all of these services are offered on a no-fault basis. So simply because support provisions are provided, it does not constitute a finding against the licensee. Again, applications for the program are right at the front end. I mean, they can be made later in the process as well, but it's completely separate and not tied to the underlying investigation of the allegation against the licensee. So the simple act of providing support does not constitute that any finding has been made against the licensee. And just again, for overall information, that it's a trauma-informed and culturally appropriate program where all support must be delivered using trauma-informed approaches, and the services must be culturally appropriate and accessible. And that's the end for me.
Thanks so much, Lainey. I think, Michelle, you're handling the questions.
Yeah, certainly. We can jump into questions. We received a number of live questions, but we did receive some questions in advance, which is where I'd like to start. So the first question we have here is, what is the process for reporting concerns around the use of titles? When an individual uses a title they are not permitted to use under the regulations. And the example provided was psychologists registered at a master's level, also completing a non-psychology PhD and not being permitted to use the title of doctor.
So, I mean, the focus of this presentation was largely more on kind of public complaints or due to reports, but absolutely, investigations of title violations constitutes a complaint investigation. So the process is that if someone is aware of or believes they are aware of someone inappropriately using title in any profession, then you would submit a complaint and it would be investigated, and the various processes that we've outlined would cover that kind of investigation.
Thanks, Lainey. Another question, this one's with respect to working outside of practice or unauthorized practice. What is the process for making a complaint if a group of professionals, or I guess an individual, is doing work that is outside of their practice?
So again, that falls under the category of kind of unauthorized practice. I think it would be important to note that the college regulates individuals, not groups of people. So if you believe there's more than one person, then individual complaints would have to be filed. There's currently a section on the website which talks specifically about unauthorized practice and gives directions for where to submit that complaint. And so I would just highlight that if the belief is that it's a group of individuals, unfortunately, we regulate individuals. So you'd have to make a number of complaints about each of them, and it would be investigated just like it is now. That won't be changing under the HPOA.
Terrific. Thank you. Next question we received in advance, is someone acknowledging the availability of the free therapy and counseling? And would this serve as a financial incentive to issue false complaints of discrimination or sexual misconduct? And what, if any, precautions will be taken to mitigate against that?
So, I mean, I think that's a valid concern that those of us who were working we had a working group preparing for support programs, and we definitely acknowledge that is a possibility. Again, the Act requires the funding of this service. So again, it's not something we've chosen to create. I would just say in terms of mitigation, there's a couple of things to keep in mind. One, there are support services programs being operated in other provinces, and the feedback is not that it's abused. So while of course the potential is there for someone to try and get free counseling, that's not, again, I don't have actual stats, but as part of our process in creating our program, we spoke with other providers in Alberta and Ontario specifically, and that's not a common occurrence. Secondly, I would say that coming forth and making a complaint about sexual abuse, sexual misconduct, or discrimination, it has a cost in and of itself, in that you're still going to be, the college is still going to be investigating the complaint, and there'll be expectations of participating in interviews and providing information. So I don't know how many people will really put themselves through that process just for some free counseling. Nonetheless, I've been in this role not role transformation, but working in complaints for a long time. And there are individuals who do take advantage of things. So it's not unheard of that it could happen. But I think the other important thing to remember is that in creating this process, the idea is that there needs to be a safe process for complainants, and people who are truly victims of sexual abuse, misconduct, or discrimination do suffer as a consequence of that. And so as a starting point, we're taking the position that if you're bringing that forward, there will be some basic questions to assess eligibility to ensure you're meeting the criteria. But we're not going to start from an antagonistic point of view to challenge as to whether or not it's really valid or not. As the complaint investigation proceeds, and as I noted in one of the slides, the support officer has the ability to assess and review new information as it becomes available. So in the event that as the investigation continues, should it come out that someone has made a false complaint, then, presumably services will be terminated at that point. So I don't want to dismiss that it is a valid concern that we all kind of recognize, but again, I just think it's not as likely as it sounds like scary to throw out that that's going to happen, but I'm not convinced that it's going to be the biggest proponent of people who apply for our support program.
Thanks, Lainey. We've received a number of questions. I'm going to try and lump them together regarding the threshold for public notices. When does it meet the threshold for a public notification on the website? So there's one, can you please comment on the threshold? Also another one talking about administrative issues that you mentioned and if those would be published on the website. And also in the process of a matter being investigated, if that also rises to the level with which it would, post notification on the website.
So the reality is that the Act spells out explicitly what must be published. So it's not about a threshold anymore. The Act specifies that all disciplinary orders have to be published, and that also includes the summary protection, which is currently the ones that we do that now, we'll publish it. So the threshold is if there's a risk to the public. So for the summary protection orders, if that gets made, there has been a finding of a reasonable risk to the public that warrants public notice. So again, that's not really a determination that we're making in terms of threshold. That's where it's slightly different now. It's a requirement that disciplinary orders be published. Where I think there could potentially be a change, and this is something that we as a college are working through, we are liaising with other colleges. Some of you might recall that in the past, all notices stayed up for a very extended period of time. There was a framework that regulatory health colleges agreed to around a 10-year frame. Given the breadth of types of orders that are now available under the HPOA, including some of those administrative matters, the colleges are working on consideration of whether or not everything needs to stay up for as long as they're currently up. So something like a summary protection order. And again, one of the other things around publication that the HPOA is doing is bringing some harmonization. So currently, if you were to look at our website, you'd see a bit of variation in terms of how long some of the legacy colleges had information posted, some of the nature of what was being posted versus other colleges. Now, as harmonization under the HPOA around publication, there should hopefully be more consistency, not just within the professions that we regulate, but across all of the health colleges. And again, in terms of what is published, that is set out in the Act. Where there will be some discussion is around length of publication. And again, there's a working group that is actively trying to come up with some principles and no pun intended, but like a disciplined approach to how to address publication. Again, being really mindful that publication has a real bearing on licensees' financial situation and their reputation. And also emotionally, it's obviously pretty scary and harsh to see your name up on a public notice on the regulator's website. So we're trying to find that balance, keeping in mind the Act has dictated certain things must be published.
Thank you, Lainey. Next question is, will complaints and discipline, I guess for us just complaints, be assessed, determined by profession-specific panels, or will they be decided by professions that are not familiar within our practice area?
Yeah, so hopefully that was asked and answered earlier, but I'm really happy to reiterate because I know it's a big concern for many of our licensees. Investigations Committee is formed in panels of profession-specific panels. So a complaint against a physical therapist that goes to the Investigations Committee is presented to currently a panel of 3 comprised of 2 physical therapists and a public member. Complaint about a psychologist goes to a panel of 2 psychologists and a public member. 100% the complaints that are brought to investigations committee are being assessed by profession specific, I don't want to say experts, but committee members.
Thanks, Lainey. I'm going to move on to the questions we received live. This next one asks, for complaints that are ongoing and persist past April 1, is the college following the HPA or the HPOA?
That's an excellent question. The Act actually answers that for us, and the Act requires that we transition to the HPOA. So if you have an open complaint that is under investigation as of April 1, it will transition to being decided under the HPOA. I'll recognize that that's unusual. For some of these ongoing complaints, we're already hearing from legal counsel that they're not happy about that, but unfortunately the Act actually specifically has a transition section that dictates that the colleges transition their files, any open files, to being disposed of under the HPOA.
Thanks, Lainey. We've received a number of questions about support workers and support programs. The first question here, will the support workers be required to use methods that are supported by evidence? How will this program be evaluated to ensure that it is both helpful to complainants and not resulting in increased complaints?
Yeah, also really interesting. Okay, so support workers is currently at the stage where, if any of you are on LinkedIn, you might have seen some postings that there's actually a request for services out to try and generate some applications for support workers, eligible support workers. And of course, that will also be in conjunction with any nominees that come from Indigenous governing bodies. The colleges are working together on generating vetting applications and generating a list of who will be appropriate support workers who meet the criteria under the Act. They're going to be, it's an independent role because again, we don't know how many people are going to want that help. We don't know how many people yet are going to find it helpful. So in terms of actually how it works, these are going to be independent contractors maintained on a shared list that all of the health colleges can draw from in the event we get a request for support worker. The other really timely question, part of your question, is about an evaluative framework or evaluation framework, I should say. And we have just launched another working group comprised of all of the colleges to put together an evaluative framework that we can begin really on April 1 as we begin to collect data across the entire program, not just specific to whether the workers are helpful, but we're building this from scratch. So none of the other health colleges have this, and we're trying to be as collaborative as possible. We don't know what to expect on April 1. I think different colleges are going to receive varying volumes of applicants, depending on the nature of the professions that are regulated. Some are probably going to generate more applications than other colleges. And we are literally building the framework as we speak. So there will be an evaluation framework to monitor and collect data to ensure that our program is effective and accessible. And but what that actual framework looks like, it's literally being built as we speak.
Thanks, Lainey. Another question about the support program. Who will be providing the counseling services? And is this a reimbursement model based on who the client chooses, or will the college be contracting specific providers? And also one question about, can individuals choose their counselor?
So all of that is going to be spelled out in the eligibility parameters. The colleges, the health colleges, with the exception of physicians right now, are in contract negotiations with a potential company that we have identified to be the service provider for our support services. It's currently under negotiation, so I don't feel comfortable announcing the name quite yet. But there will be an identified service provider under contract with each health college will have their own individual contract with that company. We are discussing, again, if someone comes to the table and already has their own counselor, again, that will be the role of the support officer to really evaluate what services are necessary, how will funding that individual's choice be appropriate. We'll want to ensure who that person is bringing to the table to ensure they meet the criteria of what our program would offer. So lots in flux, but certainly all things that are being worked on. I'm not sure if I captured all of the questions in that multi-pronged question, but.
I know, sorry, I kind of lumped a bunch of things in there. But it sounds like we'll be providing more information as we receive it. Is that fair to say?
Yeah, I mean, if there's something specific I can try and answer, but yeah.
Thank you. There is a question about support for practitioners. What kind of support is available for practitioners, and how will this impact current legal help from insurers for a practitioner? Are there any supports built in for them?
Yeah, so and unfortunately, I'm going to have to do the distinction that our colleges operate in respect of protecting the public. So we currently don't provide specific types of counseling services. We certainly in the complaints process, we are again super mindful of the stress on licensees. So when we notify them of a complaint, we encourage them to contact their insurers, as many of our licensees do through their professional liability insurance, have access to legal counsel to represent them in a complaint. And I would strongly encourage that if you are the subject of a complaint, that you do check your insurance. And if you are eligible, that you obtain counseling, not counseling, pardon me, but you obtain that legal advice because, well, there's a multitude of reasons, but the biggest one being that it serves as a buffer between you and the process, which is inherently just really stressful. As to whether or not there are changes in the insurance policies that all of you might have that would implicate or change in some way what coverage you're entitled to, I'm sorry, I can't speak to that. We're entirely separate from any of your individual insurance policies. And in terms of services that are available, I know that's an area that, the leadership in complaints, we talk a lot about that. I'm aware, like if you take something like the Law Society, that is a bit more well-resourced. They have particular programs that they do offer to their registrants as being a member of the Law Society. But I believe currently we don't have that available. And in the event we get asked for particular types of counseling services, we would be referring to, Canadian Mental Health Association. If it's a serious crisis, there's the 988 line. But we don't offer particular counseling or support services to our registrants. The one thing I would say, while they can't offer kind of emotional support, of course, we have our practice advisors. So if you find yourself in a situation where you question that you might be getting a complaint, or if you're unsure about a duty to report, or about something you're doing in your practice, then I would encourage you to reach out to our practice advisors. Again, profession specific. All professions that we license are represented by practice advisors. And so while they're not providing the type of support that I think the question was aimed at, it can be helpful, I think, to contact them. Again, I would be very careful if you call and say I'm the subject matter of a complaint. They can't assist you with that complaint. There's a bit of a distinction between the advice that's being offered as a practice advisor, but they are available in terms of broader issues around practice. But if you call and ask for help with your complaint, that's not something they can offer.
Thanks very much. I think we're at time, so perhaps we could wrap up, Diane.
Yes, thanks so much, Michelle and Lainey, and thanks everyone for joining us today. Hopefully this webinar was helpful for you. I know there are some other questions in the Q&A that we will answer and post for you. Just a reminder that our next webinar is on March the 18th at noon, and it will focus on the harmonized ethics and practice standards. So hopefully we will see some of you then. And then there will be one on restricted activities and certified practice on March 23rd. And I believe that one's at 4 p.m. Recordings are available on the website. This one will be posted as soon as the team can do that. So thanks for joining us, and have a great day.